In many families, it's customary to pass on the family home to surviving children after the parent's death. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children or anyone else while you're alive. You can live in it or rent it out during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible. You can gift a maximum of $15,000 in 2018, but gifting more does not necessarily warrant the payment of taxes, however. When you gift your home to your children, if they ever sell the house, they are responsible for paying taxes on the value gained during their ownership, as well as the value gained during your ownership. For example, if you bought a house for $100,000 and it is now worth $200,000, when your children sell the house, they will owe capital gains taxes on the $100,000 value gained, as well as any value gained during their ownership. However, assets that are left to heirs receive a step-up in cost basis. A step-up in basis adjusts the value of an asset when it passes from an owner to their heir at death. This means the value the house has gained during your ownership will not be subject to capital gains taxes when the property is sold. In the same scenario, if your children receive the $200,000 value house as an inheritance, upon selling the house, they will now only owe capital gains taxes for value added to the house during their ownership, instead of the value gained during your ownership as well. A house can benefit from the step-up in basis by passing the assets through a will, life estate, or trust. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. Many people ask, Should you put your house in a trust? The answer is probably yes, and in certain situations, the answer is a resounding yes. One of the wonderful things about revocable living trusts is there are very few downsides. If you are not familiar with a revocable living trust, think of a trust as a bucket. The bucket can hold your assets and contain a set of rules and instructions for what happens with the assets upon your passing. In that respect, the trust can function like a will in that it passes your assets to your beneficiaries. However, a revocable living trust has many benefits over a will, which may make placing your house in a trust a wise decision. For example, to administer a will, it is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate. This means it is no longer your asset from a legal standpoint. The house is owned by the irrevocable trust itself, similar to how a corporation can own an asset. Since you no longer own or have control of the asset, the home may be able to be protected from creditors or if you want to apply for Medicaid. Both revocable and irrevocable trusts are important parts of proper estate planning. However, for trusts to function, they must be used and set up properly. Improper use can have a substantial negative effect on your estate. This is a guide to setting up an irrevocable trust. When planning for your financial future, it's important to consider how your assets will be managed and distributed. One option to ensure your estate is handled according to your wishes is by setting up an irrevocable trust. The process of setting up an irrevocable trust. Establishing an irrevocable trust can be a complex process that requires a comprehensive understanding of specific laws and procedures. This involves determining the trust's beneficiaries and transferring asset ownership into the trust. Guidance from a knowledgeable lawyer can make the process easier to navigate. Each trust is created for a unique purpose, whether to minimize estate taxes, to provide for a special needs family member, or to protect assets from creditors. Determining your purpose is essential to guide the rest of the setup process. Next, select the right type of irrevocable trust. There are various types of irrevocable trusts, such as charitable remainder trusts, life insurance trusts, and qualified personal residence trusts. Each trust has its pros and cons, and an experienced attorney can help you decide the most suitable one for your circumstances. The next step is to choose your trust. The trustee is the individual responsible for managing the trust based on your guidelines. This could be a trusted friend, a family member, or a professional trustee like a bank or trust company. The chosen trustee should be reliable, honest, and well organized. Next, you need to identify your beneficiaries. Beneficiaries are those who will ultimately receive the assets in the trust. It's crucial to clearly specify who these beneficiaries are and what they are entitled to receive. Next, you will need to create and sign your trust document. The trust document is the legal agreement that outlines the trust's terms, including the trustee's responsibilities and the beneficiary's rights. After the document is drafted to your satisfaction, it must be signed in the presence of a notary. Next, store the trust document safely. After the trust document has been signed, it should be securely stored. Both your trustee and beneficiaries should know its location and how to access it if needed. Next, you will need to transfer assets into the trust. The step of transferring assets into the trust is critical. Depending on the asset type, this may require changing titles or deeds or merely transferring funds. Remember, once an asset is transferred into an irrevocable trust, it generally cannot be removed. Here are some key considerations and benefits. The laws governing the creation and management of irrevocable trusts can vary depending on the state you are located in. Understanding these state-specific laws is essential for ensuring the trust's validity and its ability to meet its intended objectives. When establishing an irrevocable trust, it's crucial to consider the tax implications. Depending on the type of trust and the assets involved, there may be federal and state tax consequences. Now, we'll discuss the benefits of an irrevocable trust. An irrevocable trust is a legal entity that, once established, generally cannot be altered or canceled without the consent of the beneficiary. It offers several benefits like tax advantages, protection from creditors, and assurance that your estate will be managed as you wish. One of the primary advantages of an irrevocable trust is the privacy and asset protection it offers. Because the assets are no longer in your name, they are safeguarded from creditors and legal claims. Do I need a lawyer to set up an irrevocable trust? Establishing an irrevocable trust can be complex and mandates a thorough understanding of the law. A lawyer can guide you through the setup process, ensure all legal stipulations are met, and help you understand the trust's implications. Setting up an irrevocable trust is a comprehensive process that involves understanding various laws, selecting the right type of trust, choosing a competent trustee, and considering both tax implications and asset protection benefits. While it may seem complex, seeking the guidance of a knowledgeable legal expert, like those at Heritage Law Office, can simplify the process and help you achieve your financial and estate planning goals. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. A life estate is a form of joint ownership that allows one person to remain in a house until his or her death, then it passes to the other owner. Life estates can be used to avoid probate and to give a house to children without giving up the ability to live in it. They also can play an important role in Medicaid planning. In a life estate, two or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. When you pass away, your debts do not expire with you. Most debt still needs to be paid off if possible, although who is responsible for paying the debt depends on the type of debt, and some assets are protected from being used to satisfy a debt. Outstanding debt may include mortgages, credit card bills, car loans, personal loans, or condominium fees. Usually, your estate is responsible for paying any debts you leave behind. If the estate does not have enough money, the debts will go unpaid. In general, debt collectors may not try to collect payment from your relatives and heirs. However, there are some exceptions. Co-signers and guarantors of a particular debt are responsible for that debt, and someone who held property jointly with you would be responsible for any debts on the joint property. In addition, spouses in community property estates may be responsible for some debt. Creditors are paid from the part of your estate that passes through probate, which means any property that passes through a will. The person who is appointed personal representative or executor of your estate is responsible for making sure the creditors are paid. The personal representative uses estate assets to pay off the debts before any money passes to heirs. If you have significant debts, it is possible that your entire estate will be used to pay creditors. Creditors cannot be paid from any assets that pass directly to a beneficiary. For example, a jointly held bank account would pass directly to the joint owner, and the funds in that account could not be used to pay creditors. Similarly, life insurance policies pass directly to the beneficiaries, so creditors do not have access to those funds. Whether or not a creditor can access funds in a trust depends on state law as well as what kind of trust it is. Contact Heritage Law Office to make sure your assets are protected. Is it better to use joint ownership or a trust to pass down a home? You may be wondering about how to pass your home to your spouse, children, or other beneficiaries after you die. A will works, but that will require them to go through the probate process, which may take a considerable amount of time and money. There are estate plan alternatives that allow the bypass of the probate process to ensure a faster, easier transition that will also be less expensive for the beneficiary. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. Joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party, or if the 2 parties were to die simultaneously. Number 2, survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive, and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust's property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. For every estate plan, it is important to start by considering your objectives. That is the first step in determining what assets should be in your trust. Oftentimes, it is easier to start by thinking about what you should not put into your revocable living trust. If a revocable living trust has the distribution set up correctly and how you desire, a revocable living trust may be appropriate for holding the bulk of your assets, with some important exceptions. Before we get into those exceptions, it is important to understand how trusts work so that we understand why those exceptions apply. Think of trusts as a different entity. The same way that an LLC or a corporation is a different entity from its shareholders. A trust is a different legal entity from the trust creator. Trusts are capable of acting independently, owning assets independently, filing lawsuits, and being sued themselves. It is because of these functions that we need to be cautious when it comes to transferring qualified assets, such as an IRA or 401k, to a revocable trust. The transfer of an IRA or 401k to a trust is similar to transferring it to a different owner, such as a different person, a different corporation, a different entity, and in doing so, the IRS considers this a taxable distribution. Similar to qualified assets, when a health savings account and medical savings account are transferred to a trust, they may be subject to taxes. Additionally, transferring a vehicle to a trust may result in the need to pay title transfer fees and additional taxes for issuing the new title. This list is not exhaustive. Other than the above-mentioned items, a revocable living trust may be a good option for the majority of your assets. This means your bank account, your house, your post-tax investment account, etc., should likely be transferred to a trust. You should pay special attention to retitling your assets to a trust to avoid unwanted taxes or other consequences. A will is a legal document that outlines your desires for distribution of your estate after your passing. Failure to create a will puts your estate in the hands of courts or state officials, which can lead to family turmoil. To be completely sure everything is correct, you should have your will prepared by a trust's and estate's attorney. Some people believe that wills are only necessary for the very wealthy or those with complicated assets. However, there are many good reasons to have a will. You can be clear about who gets your assets. You have more control and can decide who gets what and how much. Your heirs will be able to access your assets more quickly and easily. Additionally, with proper planning, you can plan to save your estate money on taxes. You can also give gifts and charitable donations, which can give tax benefits. However, even if you have a will, upon your passing, your assets will be routed through the probate process. Probate is the legal process that occurs to your estate after you pass away. This is a court-monitored process where the debts of the estate are paid and distribution is made to the heirs. The probate process will flow smoother with a will. Probate costs money and can take significant time. With proper estate planning, probate may be able to be avoided. Trusts can accomplish the same goals as a will, but oftentimes in much better fashion. When a trust is properly set up, it can avoid probate entirely. Any assets that belong to the trust will not be routed through probate. Often, a type of will, a pour-over will, is used in conjunction with creating a trust to ensure all assets are covered, even if they are not properly moved to a trust. To ensure your will or trust is done properly, contact Heritage Law Office today. The phrase life estate often comes up in discussions of estate and Medicaid planning. But what exactly does it mean? A life estate is a form of joint ownership that allows one person to remain in a house until his or her death, when it passes to the other owner. Life estates can be used to avoid probate and to give a house to children without giving up the ability to live in it. They also can play an important role in Medicaid planning, depending on your specific state. In a life estate, 2 or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. The life tenant has full control of the property during his or her lifetime and has the legal responsibility to maintain the property as well as the right to use it, rent it out, and make improvements to it. When the life tenant dies, the house will not go through probate, since at the life tenant's death the ownership will pass automatically to the holders of the remainder interest. Because the property is not included in the life tenant's probate estate, it can avoid Medicaid estate recovery in states that have not expanded the definition of estate recovery to include non-probate assets. Even if the state does place a lien on the property to recoup Medicaid costs, The lien will be for the value of the life estate, not the full value of the property. If the property is sold, the proceeds are divided up between the life tenant and the remaindermen. The shares are determined based on the life tenant's age at the time. The older the life tenant, the smaller his or her share, and the larger the share of the remaindermen. Be aware that transferring your property and retaining a life estate can trigger a Medicaid penalty period if you apply for Medicaid within 5 years of the transfer. Purchasing a life estate should not result in a transfer penalty if you buy a life estate in someone else's home, pay an appropriate amount for the property, and live in the house for more than a year. If you have any questions regarding life estates or estate planning, contact the experienced attorneys at Heritage Law Office for a free consultation. Probate is the legal process that occurs to your estate after you pass away. During this legal process, a court will monitor the process of paying your debts and distributing your estate to the proper heirs. The probate process will take several months at minimum to complete and may take longer, depending on the complexity of your estate. Through proper planning, probate can be avoided, saving time and money. Tools such as a trust, life estate, joint ownership, and payable or transfer on death designations may be able to avoid probate. A will does not avoid probate as it is designed to go through the probate process. Many seniors enjoy the opportunity to be generous to their children by gifting them monetarily. In certain circumstances, however, there is a real concern that people who may be in need of long-term nursing care in the near future should not give gifts. It can be complicated trying to adequately plan for long-term care and consider gifting. In Wisconsin, for Medicaid to cover the huge expense of nursing home care, seniors must show that they own nothing more than around $2,000, and they must also show that they have not given away money or assets over the prior 5 years. The look-back period, or the transfer penalty, would charge that senior for their generosity. Depending on the size and number of the gifts, the penalty could be substantial. Many wrongly think that there is no penalty for gifts of up to around $15,000 annually. That misunderstanding confuses tax law with Medicaid law. The Medicaid rules are entirely different from the tax rules. In the Medicaid context, gifts of any amount that are given during the look-back period can be penalized. There are exceptions, including gifts to spouses and siblings under certain circumstances, disabled children, and children who are caregivers and who live at home with the elder for a span of time. But overall, gifts and Medicaid do not belong together. The Medicaid rules are complicated, and the consequences for mistakes can be very costly. There are a number of options to protect assets and still qualify for benefits, but these options must be weighed with great care. This is why it's best to consult attorneys who are experts in Medicaid law. Contact Heritage Law Office today for more information on long-term care planning, Medicaid, and gifting. How to save over $100,000 through Medicaid planning. Nursing home costs are expensive and add up quickly. Within a short period of time, an entire life savings can be depleted by paying for the cost of a stay in a nursing home. With proper planning, however, substantial value may be able to be preserved and passed along. Here is an example of how to save over $100,000 through active Medicaid planning. Mary has a savings account worth $75,000 and an investment account worth $150,000, totaling $225,000. Mary will be requiring nursing home care starting next month. Nursing home expenses are $10,000 per month. Since Mary did not previously buy long-term care insurance or pre-plan, Mary will have to cover the costs out of pocket. Mary will have to pay out of the savings account and liquidate the investment account to pay for nursing care. In less than 2 years, Mary will be completely out of money. Medicaid is administered by states according to federal requirements. State rules may vary. For example, in Wisconsin, the Medicaid rules are structured so that once you have less than $2,000 in assets, Medicaid will pay for a required nursing home stay. Now that Mary has spent $225,000 and is out of money, public benefits will pay for Mary's nursing home care. Most people struggle with the concept of seeing their entire life savings depleted very quickly. They would prefer to transfer those assets to their children, family members, friends, or donate that money to charity, rather than seeing the money depleted. The easy solution seems to be to give away all your assets to drop below the asset limit and qualify for Medicaid. It is not that easy. Medicaid will not allow you to gift away all your assets and immediately qualify for Medicaid benefits. When gifting assets, Medicaid imposes a divestment penalty, causing an ineligibility period for Medicaid, time that must pass before public benefits will pay for nursing home expenses. The larger the value of the gift made, the longer the ineligibility period. The ineligibility period only starts counting down when you apply for Medicaid, and you would be otherwise eligible if the ineligibility period did not exist. At the time of this video, in Wisconsin, for every $303.38 given away, 1 day of Medicaid ineligibility is assessed. If Mary were to give away all her money, then apply for Medicaid, she would be ineligible for 2 years after applying and must find funds to pay for nursing home expenses. Here's one possible way to solve this issue. Again, there are different rules in different states, so be sure you talk to a professional. Mary has a total of $225,000. Mary splits the money into 2 different pieces. One that Mary keeps and turns into a stream of income, and one that Mary gives away to her family, friends, or charity. In this example, Mary converts $118,000 to a stream of monthly income. Income is treated differently than assets and do not count towards the Medicaid asset limit in Wisconsin. Mary receives the money back in equal payments over 12 months as income. We will discuss what Mary does with this cash flow in just a bit. Mary also gives away the remaining $107,000, either to individuals or to a special type of trust, an irrevocable trust. We believe an irrevocable trust is generally a better option for numerous reasons, which we will discuss in a separate video. At this point, Mary has no money remaining. She has gifted $107,000 to family, friends, or a trust, and has spent $118,000 to acquire a monthly income stream. Giving away money is considered a gift, causing a divestment period where Mary is ineligible for Medicaid benefits for a period of time. In Mary's scenario, a gift of $107,000 will cause an ineligibility period of 352 days. Now that Mary has less than $2,000, Mary can apply for Medicaid. Mary will be assessed an ineligibility period due to the $107,000 gift. However, the ineligibility period will now start counting down, and Mary will be eligible for coverage at the end of the 352-day ineligibility period. During the ineligibility period, Mary will use the monthly income stream to pay the nursing home expenses. That stream of income will expire the same time as Mary's ineligibility period, leaving Mary with less than $2,000 during the ineligibility period and when the ineligibility period ends. At the end of the ineligibility period, the income stream will stop, and Medicaid will cover Mary's nursing home expenses. Meanwhile, the assets that are set aside in the trust or gifted to individuals are saved. They are not subject to being spent on nursing home expenses. Rather than spending $225,000 on nursing home expenses and having the entire value of the assets depleted, $107,000 were able to be passed on to friends, family, or charity. Our next video will be about how Mary could have saved almost all of the $225,000 with proper Medicaid pre-planning. Medicaid planning and Medicaid applications are complicated, precise, and vary state to state. One mistake can be very costly. Contact one of our attorneys to make sure your assets are properly protected. What is a funeral trust fund? A funeral trust fund is a legal agreement that allows you to put aside funds for your funeral and burial expenses. This ensures your final wishes are respected and eases the financial burden on your loved ones. Why is a funeral trust fund necessary? A funeral trust fund is necessary as it offers peace of mind, knowing your loved ones won't have to bear the financial burden of funeral costs. In addition, it provides assurance that your funeral and burial will be conducted according to your preferences. How to set up a funeral trust fund. Setting up a funeral trust fund involves several steps. Determine the amount. Consider the type of funeral you want and the costs associated with it. Include all potential expenses such as the casket, burial plot, and services. Choose a trustee. This could be a family member, friend, or a financial institution. The trustee will be responsible for managing and disbursing the funds after your demise. Create the trust document. This should be done under the guidance of an experienced attorney to ensure the document is legally sound. Fund the trust. You can fund the trust with cash, bonds, life insurance policies, or other assets. It's essential to discuss the most suitable funding option with your attorney. Legal considerations for a funeral trust fund. Funeral trust funds are subject to certain laws and regulations. It's crucial to understand these laws to ensure the trust fund operates as intended. An experienced attorney can guide you through the process, ensuring all legal requirements are met. Advantages of a funeral trust fund. A funeral trust fund offers numerous benefits to the settlor and their loved ones. These include quick accessibility of funds. Unlike other estate assets, funds in a funeral trust are immediately available upon the settlor's death. This eliminates any delay associated with probate and ensures funeral expenses are promptly covered. Flexibility. Funeral trusts can be tailored to meet your specific needs and wishes. You have the freedom to dictate the type of funeral service you want and how the funds should be used. Financial security. A funeral trust fund can alleviate the financial stress on your loved ones after your demise. Knowing that funeral expenses are taken care of can offer them much-needed peace of mind during a challenging time. Disadvantages of a funeral trust fund. While funeral trust funds offer numerous advantages, they also have certain disadvantages. Irrevocability. Some funeral trust funds are irrevocable, meaning once they are established, they cannot be changed or revoked. You should fully understand the terms and conditions of the trust before setting it up. Costs and fees. Creating a funeral trust fund may involve attorney fees and other administrative costs. It's important to consider these expenses when deciding whether a funeral trust fund is the right choice for you. Alternatives to a funeral trust fund. If a funeral trust fund doesn't align with your circumstances, there are alternatives. Life insurance. A life insurance policy can provide funds for funeral and burial expenses. However, these funds may not be immediately accessible upon death, depending on the policy terms. Payable on death account. You could set up a payable on death account at your bank. Upon your demise, the funds in the account are directly transferred to the named beneficiary who can use them to cover funeral expenses. Planning for end-of-life expenses is an act of kindness towards your loved ones. A funeral trust fund can be an effective way to ensure your final wishes are respected and your loved ones are not burdened with unexpected expenses. However, setting up such a trust requires professional legal guidance to navigate complex laws and regulations. At Heritage Law Office, we can help you create a funeral trust fund that aligns with your needs and legal requirements. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching. Medicaid provides health coverage to millions of Americans, including eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Medicaid is administered by states according to federal requirements. The program is funded jointly by states and the federal government. The Medicaid system will pay for your care costs, including a stay in a nursing home if you meet certain qualifications. The Medicaid system has an asset limit. As of the day this video was produced, as an unmarried person in Wisconsin, you must have less than $2,000 in assets to qualify for Medicaid. If you have more than $2,000 of assets, you must first spend your assets on qualifying expenses until you drop below the asset limit. Once you drop below the asset limit, the Medicaid system will cover your costs. Assets are separated into two categories: countable and non-countable. Countable assets count towards the asset limit of $2,000. Some examples of a countable asset may include cash, your bank accounts, and stocks. Non-countable assets do not count towards the asset limit of $2,000. Some examples of a non-countable asset may include a first automobile, money prepaid for funeral expenses, or a primary residence if a spouse still resides in that home. One of the methods in pre-planning for Medicaid is to strategically turn your countable assets to non-countable assets. Doing this will help preserve the value of your assets, while dropping you below the asset limit, qualifying you for Medicaid benefits. We work with you to find the best methods and options of converting assets to non-countable assets to preserve the most value for you and fit your specific needs. Contact one of our attorneys at our Wisconsin, Minnesota, or California locations to make sure your assets are properly protected. And for more information on wills, trusts, life estates, Medicaid planning, and estate planning, can you sell a house that is in trust? If you own property and are thinking about establishing a trust to safeguard your assets, many people ask, can you sell a house that is in a trust? The answer is generally yes, although the process can be intricate, requiring a thorough understanding of the various steps involved. In this guide, we'll walk you through the basics of selling a house that is in trust, including what a trust is, how it affects the sale of your property, and what steps you need to take to sell your home successfully. We'll also offer some tips on how to ensure your sale goes smoothly and efficiently, so you can get the best possible outcome for your situation. What is a trust? First, let's define what a trust is. A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, who will manage those assets on behalf of the beneficiaries you name in the trust. The trustee has a legal duty to manage the assets in the trust in accordance with your wishes, as outlined in the trust document. There are different types of trusts, but the most common is the revocable living trust. With this type of trust, you can transfer ownership of your assets to the trust during your lifetime and retain control over them as the trustee. You can also name yourself as the beneficiary, so you can continue to use and enjoy your assets as you did before they were placed in the trust. The trust becomes irrevocable after your death, at which point the assets are managed by the successor trustee you named in the trust document. An important question to ask is, how does a trust affect the sale of a house? If you've transferred ownership of your house to a trust, the trust now owns the property, not you personally. This means that you can't sell the house yourself. The trustee must handle the sale on behalf of the trust. However, as the grantor, creator of the trust, you can give the trustee the power to sell the property by including specific provisions in the trust document. For example, you can include language that allows the trustee to sell the property at any time or only under certain conditions, such as when the beneficiaries agree to the sale. It's important to note that the trustee has a legal duty to act in the best interests of the beneficiaries when managing the assets in the trust. This includes the sale of the house. The trustee must make decisions that are in the best interests of the beneficiaries, such as selling the property for the highest possible price or using the proceeds of the sale to benefit the beneficiaries in another way. Here are the steps to selling a house that is in trust. Now that you understand the basics of how a trust affects the sale of a house, let's walk through the steps involved in selling a house that is in trust. Step 1. Determine the trustee's powers. The first step is to review the trust document to determine the trustee's powers regarding the sale of the property. If the trust document grants the trustee the power to sell the property, the trustee can begin the process of listing the property for sale. Step 2. Choose a real estate agent. The trustee should choose a reputable real estate agent who has experience selling properties that are in trust. The agent should have a deep understanding of the legal and financial aspects of selling a trust property, as well as the ability to work collaboratively with the trustee and beneficiaries. Step 3. Prepare the property for sale. Before listing the property, the trustee should prepare it for sale. This may involve making necessary repairs and improvements, staging the property, and setting a fair market price based on comparable properties in the area. Step 4. List the property for sale. Once the property is prepared, the trustee can list it for sale with the chosen real estate agent. The listing should include all necessary information about the property, including any disclosures required by law. Step 5. Accept an offer and negotiate. When a potential buyer makes an offer on the property, the trustee should review it and consult with the beneficiaries before accepting or rejecting it. If the offer is accepted, the trustee should negotiate the terms of the sale, including the price, closing date, and any contingencies. Step 6. Transfer ownership of the property. Once the terms of the sale have been agreed upon, the trustee should work with the real estate agent and the buyer's attorney to transfer ownership of the property. This may involve completing necessary paperwork and providing documentation related to the trust and the sale of the property. Step 7. Distribute proceeds to beneficiaries. After the sale is complete and any outstanding debts and expenses related to the property have been paid, the trustee should distribute the proceeds from the sale to the beneficiaries in accordance with the terms of the trust. Selling a house that is in trust can be a complex process, but by following these steps and working with experienced professionals, it can be a smooth and successful transaction. Thank you for tuning in, and if you have any further questions or need legal advice, feel free to reach out to us at Heritage Law Office. If you found this video helpful, don't forget to like, share, and subscribe for more informative content. Here's how to avoid probate. If you pass away without proper pre-planning, your assets will likely go through probate. Probate is a court-supervised process for distributing your assets to your heirs. The process can be time-consuming and expensive, and it can tie up your assets for months or even years. What is probate? Probate is the legal process of distributing a deceased person's assets to their heirs. If the deceased person had a will, the court will follow the instructions in the will. If the deceased person did not have a will, the court will distribute the assets according to state law. The probate process can be time-consuming and expensive. It can also be stressful for the family members who are trying to settle the estate. The probate process can take months or even years to complete, and during that time, the assets of the estate are usually not available to the heirs. Why you should plan your estate to avoid probate. There are several good reasons to plan your estate to avoid probate. The probate process can be expensive. Probate can tie up your assets for a significant period of time. Probate is a public process, which means that anyone can access the documents filed with the court. If you don't want your assets to go through probate, you need to plan your estate carefully. There are several ways to avoid probate, including setting up a trust, transferring ownership of your assets to a beneficiary, or giving your assets away. How can you avoid probate? If you plan your estate carefully and properly, you can avoid probate altogether. One way to avoid probate is to create a trust. A trust is an arrangement in which property is held by one person, the trustee, for the benefit of another person, the beneficiary. Trusts can be used to avoid probate because the property in the trust does not go through probate when the trustor dies. Another way to avoid probate is to name a payable on death (POD) or transfer on death TOD, beneficiary on eligible accounts. Assets that have a payable on death or transfer on death designee will not go through the probate process. Another way to avoid probate is to give away property during your lifetime. For example, you could give your assets to your children now instead of waiting until after you die. However, this may not be practical for everyone and may not have the best tax consequences for your children. Allowing your children to inherit assets allows them to benefit from a step-up in cost basis. Finally, some other estate planning tools, such as a life estate, may be available to avoid probate. There are many estate planning tools, each with their own uses. It is important to speak with an experienced estate planning attorney to find the proper tool for your individual situation. Thank you for watching this video brought to you by Heritage Law Office. If you found this information valuable and wish to learn more, don't forget to like, share, and subscribe to our channel for more insightful content. In this video, we'll talk about what is Medicaid planning and why is it important. Medicaid planning is an essential aspect of estate planning, ensuring that individuals can receive the long-term care they need without exhausting their financial resources. With the help of an experienced attorney, you can navigate the complex regulations surrounding Medicaid eligibility and develop a strategy that protects your assets while securing your future care needs. Understanding Medicaid planning. Medicaid planning involves analyzing an individual's financial situation and employing strategies to qualify for Medicaid benefits while preserving their assets. It is crucial because the cost of long-term care can quickly deplete an individual's life savings. You may wonder, what are Medicaid eligibility requirements? Applicants must meet specific income and asset limits. These limits vary based on factors like age, disability status, and household size. An experienced attorney can help you understand these requirements and determine the best approach to qualify. Here are some strategies for Medicaid planning. There are several strategies available for effective Medicaid planning. Some of these include asset transfers. Transferring assets to family members or into trusts can help you meet Medicaid's financial eligibility requirements. However, it is essential to execute these transfers strategically to avoid penalties. Here's how irrevocable trusts can help. Irrevocable trusts can protect your assets from being counted toward Medicaid eligibility. By placing assets in an irrevocable trust, you effectively relinquish control over them, ensuring they are not considered when determining eligibility. This is how annuities can help. Instead of annuities, converting assets into an income stream through annuities can help meet Medicaid's financial requirements. An experienced attorney can help you determine if an annuity is appropriate for your situation. The importance of Medicaid planning. Medicaid planning is crucial for several reasons, such as protecting assets. Proper planning ensures that your assets are protected from the high cost of long-term care, allowing you to pass on your legacy to your loved ones. Medicaid planning also provides access to quality care. Qualifying for Medicaid benefits guarantees access to quality long-term care services when you need them, without the burden of high out-of-pocket costs. Also provides peace of mind. Knowing you have a plan in place for your long-term care needs provides peace of mind for you and your family. Now we will talk about the role of an attorney in Medicaid planning. An experienced attorney plays a critical role in Medicaid planning, offering the following benefits. Experienced guidance. An attorney can help you navigate the complex rules and regulations surrounding Medicaid, ensuring you understand your options and make informed decisions. Customized strategies. Every individual's situation is unique. An attorney can develop a personalized plan that meets your specific needs and goals. Ongoing support. As your situation evolves, an attorney can help you adjust your Medicaid planning strategy to ensure continued eligibility and asset protection. In conclusion, Medicaid planning is an indispensable component of estate planning that aims to secure quality long-term care without jeopardizing your financial well-being. With the guidance of Heritage Law Office, you'll have an experienced attorney to navigate the complex regulations and eligibility requirements. Whether it's through asset transfers, the establishment of irrevocable trusts, or annuities, our tailored strategies offer asset protection, quality care, and peace of mind for you and your loved ones. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching. Life is full of surprises, new relationships, growing families, and unexpected financial windfalls. But have you ever wondered how these life events affect your last will and testament? You're not alone. Delaying the update of your will can cost you dearly, leading to potential asset disputes, loss of money, and legal headaches for your loved ones. Today, we'll make sure that doesn't happen to you. Welcome back to Heritage Law, where we simplify legal matters for your peace of mind. In this video, we'll discuss 3 very important topics for you. The process of updating a will, why it's important to keep it up to date, and common scenarios that may prompt you to make changes. Ready to secure your family's future? Let's get started. Up first, how do I change my will? To begin, a will is a legal document that outlines your wishes for the distribution of your assets and the care of any minor children after your death. But what happens when the will no longer reflects the intentions of the person who created it? There are 2 fundamental methods for updating a will if it no longer aligns with your intention. First, by drafting an entirely new will, or second, by amending the existing will with a document called a codicil. Let's explore these approaches, beginning with the first method, drafting a new will. Drafting a new will is often the favored method for updating an estate plan. However, neglecting to properly revoke the previous will may leave the new will susceptible to court challenges. To prevent such issues, it is essential to clearly revoke the old will. Here are 2 options for doing so. Option 1. Add a revocation clause. Create a new will, and within it, stipulate that you revoke all previous wills. Keep in mind, the new will must meet the same requirements as the initial one, including testamentary intent and capacity, absence of undue influence, fraud, or duress, and proper signatures and witnesses in compliance with the law. And Option 2. Revocation by destruction. Physically destroying the old will and all copies through means such as burning, shredding, or ripping out the signature. Note that this method does not permit the removal of specific provisions for change or termination. Instead, destruction through a physical act invalidates the entire will. It is still a good idea to include a revocation clause in the new will to clearly state your intentions and avoid any potential legal disputes or confusion. The second approach to modifying a will is by drafting a codicil. A codicil is a supplementary document that makes changes to an existing will. Like a regular will, codicils must show testamentary intent and satisfy all other requirements for validity. However, this method is not preferred because it leaves the person making the will with 2 legal documents. If one of them is lost, it could lead to potential challenges to the will, as codicils are not intended to serve as standalone wills. Now that you've updated your will, what should you do after? After updating your will, it's essential to take steps to secure and protect the document, just as you did with the original will. Store the original and all copies in a safe place, such as a lockbox at home or a safe deposit box at a bank. Inform the executor of the will's location. Keep the original will and its copies separate. Clearly mark copies as duplicates and include a note indicating the location of the original will, and provide a copy to a select few trusted individuals. Although you are not required to give anyone a copy, it's a good idea to leave one with the attorney who drafted the will. Have you taken any steps to secure and protect your will, and do you have any unique methods or additional precautions that you would like to share with the community? Let us know down below. And if you find this video informative and helpful, please give it a thumbs up. It really helps the channel out. Finally, our last question. When should I change my will? Estate planning is an ongoing process, and it's a good idea to revisit the terms of your will at least once a year, even if only to reaffirm them. However, certain life events may necessitate changes to your will, including divorce, marriage or remarriage, the birth of a new child, grandchild, or the addition of stepchildren, a serious and permanent falling out with a beneficiary, receiving a significant amount of property or money since your last will update, and relocating to a state with different marital property laws. Pause here for the full list. Failing to update your will after these events could lead to unintended consequences, such as assets being distributed to an ex-spouse rather than your current spouse or children, disinheriting a child or grandchild accidentally, leaving your estate to people you no longer have a relationship with, or by unintentionally excluding new family members, and a lengthy legal battle among your loved ones to determine your true intentions. Pause here again for the full list. It's crucial to keep your will up to date as your life circumstances and intentions change. Otherwise, you risk putting your family and loved ones through unnecessary stress and legal complications. Whether you choose to draft an entirely new will or amend your existing one with a codicil, it's essential to follow the proper legal procedures to ensure your wishes are honored. Don't hesitate to explore our extensive collection of in-depth articles, insightful guides, and useful resources at heritagelawoffice.com. If you found this video beneficial, you're sure to appreciate our next video. Pass down your home tax-free, recommended right here. Don't miss out, it's packed with useful information. Don't forget to like and subscribe to this channel for more beneficial videos in the future. Thank you for joining us, and we look forward to helping you protect your family's legacy.